We will call to order the Board of Election Commissioners of the City of Chicago, constituting ex officio the Electoral Board to hear and pass upon objections to nomination papers of candidates for the offices of Mayor, City Clerk, City Treasurer, and Alderman in the City of Chicago. Good afternoon. My name is Marisel Hernandez. I'm the chairwoman. Seated to my left is Commissioner Jonathan Swain, and to my right is Commissioner William Kresse. Next item on the agenda are motions. Mr. Lasker, we have no motions.
Not today.
And we do not have any Rule 20 hearings.
Correct.
So we will now proceed to the request for subpoenas. The first one is 19 EB ALD-014. There is a related case, 19 EB ALD-081, Abdul Rehman Shaikh versus Zira Quadri for Alderman of the 50th Ward.
In this case, the candidate has requested to subpoena the objector, question the objector about the preparation of the objection. The objector responded in opposition to the request, saying that the candidate's never filed a motion to dismiss, has not contested the objector's standing or the sufficiency of the pleadings. The candidate's request failed to state why the subpoena would be relevant to any issues in the case, as would be required by the Board's Rule of Procedure 19C. The hearing officer, Travis Richardson, has found that the non-compliance with Rule 19C by the candidate to fail to state why the requested subpoena would be relevant is a violation of the rule, and recommends denying the request.
Okay. Is there any discussion? Is there a motion to deny the candidate's subpoena request for non-compliance with Rule 19C?
So moved.
Is there a second?
Second.
All those in favor?
Aye.
The motion passes and the subpoena request is denied. Next item on the agenda is 19 EB ALD-027, Jorge Morales and Alejandra Hermosillo versus Yesenia Carrion for Alderman of the 10th Ward.
The objector has requested a subpoena for petition circulator Eric Gonzalez, who was alleged in the objector's petition to have certified petition sheets that he did not actually circulate. The candidate filed no response or opposition to the subpoena request. Hearing officer Chris Cohen finds that the request was timely filed, sufficiently compliant with Rule 19C, relevant to issues in the case. He recommends that the subpoena request be granted.
Is there a motion to approve the objector's subpoena request subject to subsequent approval by the hearing officer prior to service if future events in the case make the subpoena unnecessary or of limited value?
So moved.
Is there a second?
Second.
All those in favor?
Aye.
Motion passes.
Yes, just.
Next item is 19 EB ALD-061, Bruce Washington versus Zerlina A. Smith, Alderman for Alderman 29th Ward.
The objectors requested subpoenas for 8 candidate petition circulators, 1 notary who notarized those sheets, and 1 campaign manager. The candidate filed an opposition to the request. The hearing officer, Linda Crane, reports that after a hearing on the subpoena request, the parties reached an agreement where the candidate would voluntarily provide the relevant affidavits from the 10 individuals for whom the subpoenas were requested. So the hearing officer recommends that the board deny the request, but do so without prejudice, so that the objector may renew the request in the event the candidate fails to provide the promised affidavits. I agree with that recommendation.
Is there a motion to deny the objector's subpoena request without prejudice due to the candidate's promise to provide relevant affidavits from the individuals named in the subpoena request?
So moved.
Is there a second?
Second.
All those in favor?
Aye.
Motion passes.
Madam Chairwoman, for this 4th case, the attorney representing the objector who's made the subpoena request has contacted me that he's currently in hearings downstairs.
I know, I'm here now.
Oh, he is, I'm sorry.
There
Okay.
he is. Okay, so that is 19 EB ALD-062. There is a related case, 19 EB ALD-082. It's Armando Ramos versus Majid Mustafa for Alderman of the 50th Ward. Mr. Lasker.
The objector has requested to subpoena a petition circulator named Abdul Rehman Shaikh questioned him about the circulation of the sheets he signed as the circulator. The candidate filed opposition to the request, stating there's no relevant purpose for the proposed subpoena, and because the objector failed to comply with Rule 19 by stating what the relevance would be. The hearing officer, Travis Richardson, has found noncompliance with Rule 19C with the candidate's failure to state why the requested subpoena would be relevant to an issue raised in the objector's petition. He therefore recommends denying the subpoena request for noncompliance with Rule 19C, and I agree with the recommendation.
There is counsel here.
Yes, Your Honor.
Okay.
Please identify yourselves for the record, gentlemen.
Attorney Frank Avila on behalf of the objector Armando Ramos.
And Ross Seckler, S-E-C-L-E-R, on behalf of the candidate.
Okay. And Mr. Avila, I'll let you go first.
Yes, Your Honor. Every requirement has been checked in terms of that we submitted our request and attached our subpoenas. We filed them in writing. It was there before 5 p.m. We included their name, we included the purpose, and we included the relevance. What this boils down to is the hearing officer believes that we did not include the relevance, or that is incorrect, and based on that kind of higher standard, many subpoenas would fall. Insofar as it says the purpose is to question this circulator. And then the rest of the part of the sentence says, because he was a circulator for the candidate. And we have objection to circulator for the candidate. So it's completely known what the purpose is, what the relevance is, and it's how many are done. And there's nothing that says you have to cite to something else or go on some kind of long written explanation. The purpose is for questioning the circulator, and then the circulator circulated sheets.
Okay, thank you. Mr. Seckler?
Only to state that the objector, in this case, did not comply with the rules. We agree with the recommendation of the hearing officer, which was further confirmed at argument today.
Thank you. Mr. Avila, I believe that on your request, you stated it was to question vis-a-vis the circulation of the sheets he signed as the circulator.
Correct. The purpose is to question. The relevance is that he was a circulator who circulated sheets.
Okay, but what's the relevance? Any circulator could circulate sheets.
But
I guess the question
we
is...
objected to these ones, and we... So
But the purpose is, I'm just trying to understand, because what we're looking for is a sentence saying, what is the specific issue? What is the relevance? Aside from, circulation of the sheets is very broad and vague and applies to everything and anything. And
But
that's,
I don't
was our
think it's
issue.
vague. It could be broad, but there's no requirement that you have some level of sufficient specificity. It is broad, it's not vague. We object to this circulator, and we want to question him. That's the purpose. And the relevance is that he circulated sheets, and we objected to them.
Are there any further questions? Okay.
Yeah, okay. Again, the relevance is,
That he circulated sheets, and we objected to that circulator.
But it has to be an underlying...
Well, the objection is the circulator did not circulate in their proper person. It's a proper objection, and it's in our objection.
So is it, well, I know it may be in your objection, but we need it separately in the subpoena request. So I think if you had said that it was because that circulator may not have been the individual who circulated those petition sheets, that might have clarified the reason for the subpoena request.
Madam Chairwoman,
Yes.
if I may remind the commissioners and parties that Rule 19C serves at least two very important purposes. One is for administrative efficiency. As we all know, we have a high volume cases that all have to be handled expeditiously. When the relevance is not included in the 19C subpoena request, then the hearing officer, the opposing party, the general counsel, and the commissioners all have to dig through the case file to find out if there's relevancy. And secondly, subpoena power is a great power, and it should not be taken lightly. And this board has a tradition of requiring there to be at least a minimal showing in the record, in the written record, as to a proper foundation for the extreme authority of issuing a subpoena against somebody. And in this situation, not only did the hearing officer find that he had to spend extra administrative time to determine what the relevance would be, but the general counsel had to. And you've asked several questions here today. It took several questions even just to get the relevance.
Well, and I think that an objection could state, let's say, 10 different objections, but the subpoena may be more narrow as to one particular issue, and that is what is needed in the subpoena request.
And there are cases like that, Madam Chairwoman, where the request for the subpoena may be valid for some issues, but overbroad for others. And the hearing officer in that situation may say, I'll grant the subpoena, but we're going to limit the scope of it, particularly if you're asking the person to bring documents along with. Maybe we will limit the scope to the way that the person circulated the petition, and eliminate the scope to include the residency of the circulator, if that's also an issue.
Okay. If there's no further discussion, is there a motion to deny the objector's subpoena request for noncompliance with Rule 19C?
So moved.
Is there a second?
Second.
All those in favor?
Aye.
Motion passes. Thank you.
Thank you, Your Honor.
Counsel. Next item, next case is 19 EB ALD-099, Renee G. Elms, Peter Rivera, Renee M. Wozniak, Maria G. Oriel, and Evelyn Raza versus Berto Aguayo for alderman of the 15th Ward.
In this case, the objector requested a subpoena for a petition circulator named Roberto Aguayo Jr. for the stated purpose of testifying about the improper circulation of petitions, which was stated to be relevant to the pattern fraud allegation in the objector's petition. The candidate did not file any opposition. The hearing officer did find that the proper purpose and proper relevancy was contained within the timely filed request. He recommends granting the request.
Is there any discussion? Questions? Okay. Is there a motion to approve the objector's subpoena request subject to subsequent approval by the hearing officer prior to service if future events in the case make the subpoena unnecessary or of limited value?
So moved.
Is there a second?
Second.
All those in favor?
Aye.
Motion passes. Next on the agenda is 19 EB ALD-124 with a related case 19 EB ALD-142, Kelly Martin and Jessica Anderson versus Maya Hodari, alderman for the 20th Ward. Mr. Lasker.
The objectors have requested to subpoena a circulator named Sharik Dew to provide testimony about his or her residence address at the time of circulation. The candidate filed opposition to the request, stating that the requested documents and testimony are not relevant to any valid objection. Although paragraph 12 of the objector's petition alleges that circulator Dew, quote, did not write an accurate and correct residence address upon petition sheets that bear his circulator's name, end quote. The candidate argues that an erroneous address is not, standing alone, a basis for invalidating petition sheets or signatures. The candidate further asserts the broad scope of the documents requested would be overly intrusive in addition to being irrelevant. Hearing Officer Linda Crane recommends denying the request because it seeks testimony documents that would be probing an irrelevant issue. The General Counsel further finds that the Electoral Board has previously ruled that an incorrect address on a circulator's affidavit without any additional allegations against that circulator is not grounds for invalidating those petition sheets. So here, although the request did relate to a paragraph of the objector's petition, the hearing officer is really finding that that paragraph does not raise the proper claim for which relief can be granted. So the hearing officer recommends denying the request, and the General Counsel agrees.
Is there any questions, discussion? If not, is there a motion to deny the objector's subpoena request for noncompliance with Rule 19C by failing to state how the subpoena would produce evidence relevant to a proper basis for invalidating any petition sheets or signatures.
So moved.
Second,
Second.
all those in favor?
Aye.
Motion passes. Next case is 19 EB ALD 126, Raul Hernandez versus Byron Cicho Lopez, Alderman for the 25th Ward. And there is a related case, just to note, 19 EB ALD 117. Mr. Lasker.
The objector has requested 5 subpoenas for individuals and entities for the purpose of obtaining evidence about the candidate's residency, which is relevant because it's challenged in paragraphs 3 through 5 of the objector's petition. The request includes subpoenas for documents from Chicago Public Schools and the Illinois Secretary of State's office, and 3 individuals who purportedly have knowledge about the candidate's residency as his potential current, prior, or future landlords. Some of this evidence may also be used in support of paragraph 2 of the objector's petition, which alleges that the candidate has undergone a legal name change that he failed to disclose on his nomination papers. The candidate opposed the subpoena request as overly broad, but did not contest the relevancy of the evidence that's sought. So the hearing officer, Christopher Agrella, recommends granting the request for all 5 subpoenas. While there might be some overlap of issues for which the evidence would be relevant, it is relevant to the 2 issues in the objector's petition and would not unduly burden the case.
Thank you. Any questions? If not, is there a motion to approve the objector's request for 5 subpoenas for evidence related to paragraphs 2 through 5 of the objector's petition?
So moved.
Is there a second?
Second.
All those in favor?
Aye.
The next item is 19 ALD-127, Nathaniel Moore versus Jedediah Brown, Alderman 7th Ward. Now this one, Mr. Lasker, we are tabling this for, at this
Yes,
time?
we put it on the agenda in hopes of receiving the hearing officer recommendation, but have not yet, so it'll be on the agenda for next week.
Okay.
We sent the recommendation out.
When?
I got it yesterday.
Late yesterday, we first sent out an email text format and in a Word document, and it was refiled. So I think that's why it didn't get to you in a timely manner. It wasn't initially sent out in the proper format.
Have the parties reached an agreement on the request?
No.
Then we'll table this to next week. So that's my
For
recommendation.
the next meeting.
Motion to table.
I move the table to the next meeting on this line item.
Is there a second?
Second.
All those in favor?
Aye.
All 5 subjects.
Next case is 19 EB ALD-130, Choriano Sanzoni versus Michael Scott Jr., Alderman 24th Ward. Mr. Lasker?
The objector has requested a total of 19 subpoenas, which includes 18 circulators, that includes the candidate, and 1 notary public. That's the purposes for testimony. The relevance stated is that all of these individuals are challenged in the objector's petition for various circulator and notary irregularities, such as, but not including, such as, but not limited to, not personally appearing before the notary. The candidate did not file any opposition. Hearing Officer Christopher Agrella recommends granting the request for all 19 subpoenas as they are relevant to issues raised in the objector's petition.
Are there any questions? If not, is there a motion to approve the objector's request for subpoenas for 18 circulators and 1 notary public as identified in the objector's request?
So moved.
Is there a second?
Second.
All those in favor?
Aye.
Motion passes.
I'm going to sign those now.
I'll wait. Our next case is 19 EB ALD-131, Kevin Bailey versus Bernard Newell, Alderman 20th Ward.
The objector submitted 2 subpoena requests, the first of which applies to board employees and board documents related to the chain of custody of the objector's petition after it was filed with the board. The second subpoena request stated simply that it was for, quote, all objector Bailey petitions and affidavits, end quote. The candidate did not file any opposition. Hearing Officer Martin Green recommends denying the objector's request because under Board's Rule 19, subpoenas are not necessary for board documents and employees. We will make those individuals and documents available upon the filing of a notice to produce. Thus, the objector may still obtain the testimony and documents he is seeking, but no subpoena is needed. That addresses the first request. As to the second request, it is broad and ambiguous as to really what's being sought. So a motion to deny is recommended.
Thank you. Any questions? If not, is there a motion to deny the objector's subpoena request as unnecessary under Rule 19, which allows the objector to file a notice to produce in which he requests the testimony and documents he would like from the board?
So moved.
Is there a second?
Second.
All those in favor?
Aye.
Motion passes. Next item is 19 EB ALD 138, Kevin Bailey versus Cassius Rudolph, Alderman 20th Ward.
Here again, the same objector, Kevin Bailey, has filed a subpoena request for, quote, all objector Bailey petitions and affidavits, end quote. Again, candidate opposes the request, as failing to specify specifically which petitions and affidavits are sought. Hearing Officer Joseph Morris further finds that if the objector is seeking board documents, he can simply file a notice to produce. So a motion to deny is recommended.
Questions? If not, is there a motion to deny the objector's subpoena request for noncompliance with Rule 19C?
So moved.
Second?
Second.
All those in favor?
Aye.
Motion passes. Next item is 19 EB ALD 139, Kevin Bailey versus Charles Hilliard, Alderman 20th Ward.
Again, objector Kevin Bailey filed a subpoena request seeking all objector Bailey petitions and affidavits. If those are board documents, no subpoena is necessary. If they're not board documents, then the subpoena request is not specific enough. I recommend a motion to deny.
Any questions? If none, is there a motion to deny the objector's subpoena request for noncompliance with Rule 19C?
So moved.
Second?
Second.
All those in favor?
Aye.
Motion passes. Next case is 19 EB ALD 142 with a related case, 19 EB ALD 124, Kevin Bailey versus Maya Odari, Alderman 20th Ward.
And we're getting there. Objector Kevin Bailey again filed a request for subpoenas for all objector Bailey petitions and affidavits. Candidate opposed the request is overbroad and non-compliant with Rule 19C. Hearing Officer Green agrees, so is General Counsel, recommending the motion to deny.
Okay. Any questions? If not, is there a motion to deny the objector's subpoena request for noncompliance with Rule 19C?
So moved.
Second?
Second.
All those in favor?
Aye.
Motion passes. Next case is 19 EB ALD 144, Kevin Bailey versus Quandra D. Spikes, Alderman 20th Ward.
The objector filed a subpoena request for all objector Bailey petitions and affidavits. Again, overly broad, no subpoena needed for board documents, non-compliant with Rule 19C. Recommended motion to deny.
Any questions?
No.
None. Is there a motion to deny the objector's subpoena request for noncompliance with Rule 19C?
So moved.
Second?
Second.
All in favor?
Aye.
Motion passes. Next case is 19 EB ALD 146, Robert Bank and Ronald Ernest versus John Arena, Alderman 45th Ward.
The objector has requested subpoenas for 7 individuals, which includes the candidate and the candidate's attorney of Burton S. Orgelson. While the request lists the names and addresses of the individuals, there's nothing in the request stating the purpose of the subpoenas or the relevancy of the subpoenas to an issue of the case. The candidate filed an opposition stating that the failure to identify the purpose and failure to identify the relevancy is a violation of Rule 19C. Hearing Officer Barb Goodman recommends denying the request as non-compliant with Rule 19C. I would note that the objectors have also filed what they purported to be a Rule 20 motion requesting additional argument before the board. Rule 20 applies to after a hearing officer has entered a final written recommended decision. It's my understanding hearing officer Goodman has notified the parties that the motion is deemed untimely. Nonetheless, Rule 19C does require specificity. We've talked about the administrative purposes and also the board's interest in having a solid written record justifying, showing the justifications for granting a subpoena, which is a very big power. I agree with the motion to deny the objector's petition non-compliant with Rule 19C.
And gentlemen, would you identify yourselves?
Yes, I'm Robert Bank, the objector, pro se.
Ross Seckler, S-E-C-L-E-R, appearing on behalf of the candidate.
And Mr. Bank?
We requested subpoenas on Friday, December 13th, which was within 5 business days after the first hearing per Rule 19C. This was the day after we filed our response to the candidate's motion to dismiss. The request simply listed 7 witnesses and their addresses and attached proposed subpoenas, which asked for document production as well. We did not specify why the witnesses are relevant at the hearing. However, each witness' relevance to the verified petition, except for Mio Volopic, was addressed in our response, filed, and served on the opposing party the day before. Candidate can't claim surprise or prejudice that they don't know why each witness will be called to testify or why the documents requested are relevant and necessary, because it was laid out in the response to their motion to dismiss, and the documents were mentioned at length in our verified petition.
Mr. Seckler?
We obviously agree with the recommendation of the hearing officer. The request does not comply with Rule 19C of the board's rules.
Mr. Bank, were you present when we were discussing the other case regarding how important it is to state?
I did.
Yeah, and that's basically what applies in this case, because because these hearings have to be conducted so quickly and efficiently, we don't have the luxury of looking back and connecting your subpoena request to your objections. You have to state in very succinctly but completely why these subpoenas are relevant, and that is the issue. And I know with both say you're doing this, on your own. But unfortunately, these are the rules that apply in this case, whether you're an attorney or you're pro se.
Do we have a chance to appeal this decision?
They haven't.
I may answer that the final decision of the Electoral Board, which would inherently include today's decision as a part thereof, is appealable under Section 10-10.1 of the Election Code. We may seek judicial review in the Circuit Court of Cook County after the board enters its final written decision.
Okay, thank you.
Just for the record, they do have an attorney.
That was gonna be my question.
Initially pro se, we had an attorney, and I'm pro se again.
Oh,
So at the time that this is before the hearing officer, you were represented by counsel? Or no?
I believe this was after we had counsel.
This was, okay.
If I may also just let the record reflect that Rules 19C's requirements are really not that burdensome. They are very frequently complied with a single sentence, maybe 2. It doesn't take much to state the relevancy, but again, that makes a nice written record. When these cases do go up on judicial review, then the court has an opportunity to see a written record justifying the powerful issuance of this.
any further questions?
Just for the record, did your counsel file a withdrawal?
No.
Okay, I just want to make sure we have the proper parties for the future services.
Okay.
We'll see to it. Thank you.
All right.
Is there a motion to deny
Thank
the
you.
objector's subpoena request as non-compliant with Rule 19C?
So moved.
Is there a second?
Second.
All those in favor?
Aye.
Motion granted.
Thank you very much.
Motion passes. Sorry. Next case is 19 EB ALD-148. There is a related case, 19 EB ALD-123, Kevin Bailey versus Jennifer O. Maddox, Alderman, 20th Ward.
The objector filed a subpoena request, as we've heard before, for, quote, all objector Bailey petitions and affidavits, end quote. Candidate filed no opposition, but hearing officer David Shostakis does recommend denying the request as non-compliant with Rule 19C for reasons we previously stated as well, and I concur.
Any questions? If not, is there a motion to deny the objector's subpoena request for non-compliance with Rule 19C?
So moved.
Is there a second?
Second.
All those in favor?
Aye.
Motion passes. Next case is 19 EB ALD-150 Kevin Bailey versus Jeanette B. Taylor, Alderman 20th Ward.
The objector has filed a subpoena request requesting all objector Bailey petitions and affidavits without any more specificity. Candidate filed opposition for non-compliance with Rule 19C. Hearing officer Kevin Bry recommends denying the request as non-compliant. I agree.
Any questions? If not, is there a motion to deny the objector's subpoena request for non-compliance with Rule 19C?
So moved.
Second?
Second.
All those in favor?
Aye.
Motion passes. Next case is 19 EB MUN-006 Shajan Kuyakosi and Chantia Kindle versus Susanna Mendoza, Mayor, City of Chicago.
We do have a pending subpoena request in this case. However, late yesterday evening, the objectors, or at least one of the objectors, filed a motion to withdraw. The objector's attorney has informed me that they are in the process of filing this motion to withdraw for the second objector. Based on the request for the withdrawal, we're going to pass on this subpoena request basically as moved.
Okay.
Do you want me to move to table this one as well?
Yes, please.
Okay, then I move to table this to the next meeting.
Second?
Second.
All those in favor?
Aye.
The motion passes. Next case is 19 EB MUN-021 Carisha Cariel, Melvin Gunn, and Ronisha Jobin versus LaShawn K. Ford, Mayor, City of Chicago.
The objectors here have requested a total of 19 subpoenas in 5 different categories. The objector's subpoena request was quite detailed in regards to the purposes and relevancy. The hearing officer is going to, I will be getting to the part where the hearing officer is recommending approval in part or denial in part. But to get to the categories, the first category is 13 subpoenas for petition circulators who are named in paragraph 15 of the objector's petition and who are alleged to have engaged in a pattern of fraud. The second 2 subpoenas would be for notaries who are named in paragraph 16E of the objector's petition and are alleged to have notarized petition sheets outside the presence of the circulators. The third category is 2 subpoenas for the chairperson of the candidate's campaign finance committee, someone named Cassandra Ford, and the committee's treasurer, Thomas Huguet. The fourth category is 1 subpoena for the candidate himself, LaShawn Ford. And the fifth category is 1 subpoena for records from Wintrust Bank, which is where the candidate's campaign finance committee allegedly has its bank account. The candidate filed an opposition to the request, setting forth reasons why he believes all requested subpoenas are, quote, overbroad, irrelevant, and overly burdensome. Hearing officer Mary Meehan filed a recommendation to approve in part and to deny in part the objector's petition as follows, also with limitations on the approvals. She recommends approving the request for the 13 petition circulators alleged to have engaged in a pattern of fraud. However, she recommends limiting the document request portion of the subpoenas to apply only to the documents that are readily in the possession of the circulator, instead of a blanket request which may lend itself to a possibly overburdensome fishing expedition. I would note that the requested documents would relate to each circulator's proof of residency from August 8th to November 26, 2018, and their service as circulators of candidates' petitions. My understanding of what Ms. Meehan is saying is that we don't want people to be put in the burden of having to go seek out documents that are not in their possession, because they ought to probably have responsive documents that would be good enough. For the second category, she recommends approving the request for the 2 notaries alleged to have notarized petitions outside the presence of the circulators. But she recommends striking the document request portion of those subpoenas because she does not believe that there would be documents that would be substantially relevant to the issues for which they'd be brought forth. Notaries either were in front of the circulators or not at the time that they were notarized, and I think that's a reasonable limitation. As to the third category, Ms. Meehan recommends denying the request for the chair and the treasurer of the candidate's campaign finance committee. She notes that there's nothing in the objector's petition that would make their testimony or their documents relevant to any material issue in the case. The objector argues that these individuals would have access to information about when the campaign hired and how they paid their circulators. The hearing officer believes that that's not relevant to the manner in which they circulated their petitions, which is the issue that's raised in the case. They may have been paid or they may not have been paid. That wouldn't change the manner in which they, or affect the manner in which they circulated. As to the fourth category, she recommends denying the request to subpoena the candidate because the subpoena request fails to explain the purpose of the subpoena for this particular subpoena or why the candidate's testimony would be relevant to the issues related in this case. Therefore, as to this particular subpoena, the request fails to comply with Rule 19C. I would point out that I did spend the time to look through the objector's request, and in the body of the request itself, there's nothing that mentions any subpoena for the candidate. There is then a table of these categories that's provided where the candidate's name and address does appear, but there's no explanation whatsoever as to why that subpoena would be issued. Finally, the fifth category, hearing officer recommends denying the request to subpoena records from the Wintrust Bank because, again, the financial records relating to how the campaign may have paid its petition circulators is not relevant to the manner in which those sheets were actually circulated. I would have to say that I do agree with the hearing officer's detailed recommendation, which was also in response to a detailed request. I agree with her limitations, and it's a bit lengthy, but I would recommend a motion to, well, I would also point out that because the hearing officer is recommending limiting the subpoenas to remove some of the language on documents requested to be brought along with the witness, that the subpoena forms that were attached as required by Rule 19C would have to be amended. So I would suggest the board, if it chooses to grant any subpoena requests here, authorizes general counsel to sign on the chairwoman's behalf after the parties have amended the subpoena forms to the satisfaction of the hearing officer in compliance with these limitations. So I would recommend that motion.
Okay, and so, are there any questions? If not, is there a motion to authorize the board's general counsel to deny in part and approve in part the objector's subpoena request with limitations as stated in the hearing officer's recommendation on revised subpoena forms submitted by the objectors in compliance with said limitations?
Along with the authorization of the general counsel to sign.
Yes, I agree.
I got that, okay. That, in that case, yes, I so move.
Is there a second?
Second.
All in favor?
Aye?
Motion passes. Next on the next case is 19EB MUN-022. There is a related case, 19EB MUN-023, Hector Escarzaga versus Ana Valencia, City Clerk, City of Chicago.
The objector has filed a request to subpoena the candidate. Whether the request failed to provide any explanation as to the purpose of the subpoena or why it would be relevant to the case, the objector also failed to provide the draft subpoena form that is required by Rule 19C. The candidate did not file any opposition. The hearing officer in this case actually did not file a recommendation on the subpoena request because on December 18th he did submit a final report and recommended decision in the entire case. He's recommending granting the candidate's motion to dismiss the case. So I would recommend, in compliance with my own observations of the non-compliance with Rule 19C on the subpoena request, that we do a motion to deny the subpoena request, failure to comply with the rule, and then we will, in the board's next meeting, reach the merits of the hearing officer's final recommended decision.
Your Honor, I did
Well,
comply.
excuse me,
I'm sorry.
I'm sorry, can you identify
My
yourself?
name is Hector Escarzaga, I'm the objector.
And you're not, you're pro se?
Yes, I'm pro se.
Okay.
On December 19, I submitted a physical copy of the request to subpoena to the candidate and the notary. That was stamped on December 12th, 151. I provided a brief statement, a brief detailed statement of why I'm subpoenaing a candidate, and I emailed that to council representing the candidate and as well as the board of election on December the 13th, and I did comply with Rule 19-C.
According to the hearing officer's report, Mr. Swain.
Rule 22 was also filed here.
I'm sorry?
Rule 20 was also filed.
Right, the Rule 20 is not right at this moment because it's only after there's a hearing officer's report that has been approved by the board. But according to the documents we have at the hearing officer's report on this, you failed to provide any explanation as to the purpose of the subpoena.
I did provide detailed purpose of why I wanted to subpoena, and I emailed that to him. I had proof of that,
Or why it's relevant to the case.
and it was relevant to the case, Your Honor. because
Did you, and to whom did you send it?
to the Board of Elections and to the hearing officer and to the candidates or the objectives council.
When did you make the request for subpoenas? You said,
Prior to the hearing, because I needed the subpoenas to be part of my, the witnesses to be part of my testimony, which they didn't allow me to do.
Sir, did you say that was December 19th?
yeah,
No, I'm
because,
sorry, yeah.
okay, I thought, yeah, that's.
Yeah, no, I'm sorry, it's December 12th.
Well, what we have in the file is a subpoena request that's on the board's template form.
December 13th, I'm sorry.
Okay,
This is dated December 12th with our timestamp.
okay.
Okay, December 12th, and it was emailed to them on the 13th. It was emailed to,
And is that the subpoena request that you?
Yes, that's right.
That one page?
it was one page, followed by a statement, followed by an attachment and a statement to the Board of Elections and to objective, or to the candidates council.
Okay, and you said followed by, when did you?
On the 13th.
The same time you filed the subpoena
Well,
request?
I filed the request for subpoena in person, and then I attached it to the email, and I submitted that on the 13th. After the Board of
But
Elections told
what
me
was
the
filed
procedures.
with the board? Just the subpoena request?
The subpoena request and a statement stating why I wanted the subpoenas. And I was actually advised by the Board of Election that I needed to provide a statement to comply with Rule 19-C.
Well, I'm not seeing the subsequent filing in the case file here. I'm holding the original case file.
So it was followed by an email, sir.
I understand, but I'm not seeing the email in the case file.
I got a copy
So
right here.
Where's who's the email addressed to?
Addressed to the Electoral Board at chicagoelections.net. And it was also addressed to FT Pedesal at meritech.net, which is hearing officer, and Mike Casper, and another individual.
So I'm not seeing that email transmission in the official case file. I guess given the fact that the hearing officer did just recently submit a final report and recommended decision, the objector has already filed his Rule 20. I think at this point, we should entertain a motion to table this matter. We can take the subpoena request with the case. If the case survives the motion to dismiss, we can then have the Electoral Board staff look for that email, get it in the case file, and address the issue there.
That's appropriate. Is there a motion to table?
Motion to table and consolidate with the upcoming ruling on this matter.
Second.
Okay, all in favor?
Aye.
Motion
Thanks.
passes. Thank you, Mr. Escarzaga.
When's the
Next,
upcoming ruling, sorry?
I'm sorry?
The next upcoming ruling on that?
Well, we're gonna,
We are anticipating, it's not set for sure yet, but we're anticipating next week, Thursday.
Okay.
And you will be notified.
You will
Thank
be,
you very
it will
much.
post the
Appreciate it.
agenda at least 48 hours ahead.
Thank you.
Next case is 19 EBMUN-023 Anthony Suter versus Anna Valencia, City Clerk, City of Chicago. There is a related case, 19 EBMUN-022.
This is an unusual one. It actually appears that the request that's in the file was filed erroneously, that it had the wrong case number on it. It had this case number on it, so it ended up in this case file. But the parties who are named in the caption are not the parties for this case. And it was actually Mr. Escargaza, who just left.
No, he's still there.
Oh, okay. So the request was identical to case number 22, except that it had this case number on it and different parties. So he is not a party to this case. So I believe that this just ended up in the wrong case file because it had this case number on it, but it does not actually belong there.
So is your recommendation to pass this case?
Well, I guess let's actually deny the request as irrelevant to me, just so it's clear that the request has been denied.
Is there a motion to deny the request as erroneous and removed?
So moved.
Is there a second?
Second.
All those in favor?
Aye.
Motion passes. Next case
Just
is,
a quick question. So if I'm hearing this last case correctly, there is a report in the, or a request in the file that has the previous owner's name. Is that right? So is that the document that he would never represent?
No, because I'll show you the differences. Case number.
You examined it, I'll take a look.
Yeah, case number 22 has these names and the case number 22 on it.
Okay.
Now, for this case 23, it says case number 23, but it has the name of the wrong candidate and the name of the wrong objector on the top. I have scratched out. That's my handwriting from my notes. That's my personal copy. It's just a bonus.
Okay.
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 Thank you.
Next case is 19 EBMUN-026 Sean Kowari versus Melissa Conyers Urban, City Treasurer, City of Chicago.
The objector here filed a subpoena request for some 215 individuals who allegedly have knowledge about, quote, the circumstances of the striking through and replacing of, end quote, petition signers' addresses on the petition sheets. The candidate filed opposition stating that the subpoena request is, quote, wildly overbroad, not seeking relevant information and for harassment purposes only, end quote. Hearing Officer Christopher Grella has not submitted a recommendation specifically to the subpoena request. However, he has filed a final report and recommended decision in which he mentions that the subpoena request should be denied. But he's also recommending granting the candidate's motion to strike and dismiss the entire objector's petition. Because we just received that recommendation and the party had the right to file the Rule 20, we've not put that case on the agenda for today. I would request the motion to enter and continue the objector's subpoena request to be taken with the case in chief that will be approved or denied along with the hearing officer's recommendation next week.
Is there a motion?
So moved.
Is there a second?
Second.
All those in favor?
Aye.
Motion passes. That concludes the subpoenas for today. Subpoena requests for today. Now we will proceed to the consideration of hearing officer reports and proposed final decisions.
Madam Chairwoman and Commissioners, we do have 24 cases on the docket for this section today. I do just want to inform you that they all involve either a candidate withdrawal, which would render any case moot, or an objector's motion to withdraw, all of which the hearing officers recommend granting.
Okay. First case is 19 EB-ALD-002. There is a related case, 19 EB-ALD-041. Arlise Udici versus Betsy Jovan Watkins for Alderman of the 23rd Ward. And in this case, the candidate has withdrawn. Is there a motion finding that the candidate's withdrawal has rendered the objections moot, and therefore dismissal is appropriate in this case?
So moved.
Is there a second?
Second.
All those in favor?
Aye.
Motion is, passes, and it is therefore ordered that the name of Betsy Joanne Watkins, candidate for alderman of the 23rd Ward, shall not be printed on the official ballot for the municipal election. Should we just wait for the
Yes, we
answer?
said we waited for the answer.
Okay. Next case is 19 EB ALD-003. There is a related case, 19 EB ALD-039, Arlise Udici versus Richard Myers, alderman for the 23rd Ward. Again, in this case, I find that the candidate has withdrawn and would entertain that a motion stating that the objections are moot and therefore warrant dismissal.
So moved.
Is there a second?
Second.
All those in favor?
Aye.
Motion passes, and it is therefore ordered that the name of Richard Myers, candidate for office of alderman for the 23rd Ward, shall not be printed on the official ballot for the general election.
Madam Chairwoman, if I may interrupt.
Yes.
I just want to advise anyone in the room, if there are any parties to these cases in the room, these are final decisions that will be issued. They'll be signed immediately following the hearing today. We would request that you stick around and receive your copy of the final decision if you are here. Pursuant to section 10-10.1 of the Illinois Election Code, service upon you of the final decision, and then start the clock for your ability to file for a petition for judicial review. Otherwise, for those who are not in the room, they will be mailed to you pursuant to section 10-10.1. Thank you.
Next case is 19 EB ALD-039 with related case 19 EB ALD-003, Nicholas George Dershel versus Richard Myers, alderman of the 23rd Ward. The candidate has withdrawn, and I would entertain a motion that the objection is moot and therefore rendering this dismissed. Is there a motion?
So moved.
Is there a second?
Second.
All those in favor?
Aye.
Motion passes, and it is therefore ordered that the name of Richard Myers, candidate for alderman of the 23rd Ward, shall not be printed on the official ballot for the general municipal election. Next case is,
One quick question.
Yes.
For, council. Council, we called in our previous case with Guidance versus Myers. We have the related case open now.
Yes.
When we rule on the primary case, is that automatically rule on the secondary case, or do we have to make a motion on the secondary case?
We could call both of the cases together. We do have to enter a final decision on both of the cases, which could be done on one motion. I would point out that the candidate's filing of his withdrawal affidavit, that's what automatically moots any case, in all cases that may be against them.
okay. So, the next one is, I don't see 002.
But 002 was the first on the agenda in this section, so we've already dealt with that one.
Okay, so, the next case, I still have to call it 19 EB ALD-041, Nicholas George Dershel versus Betsy Joanne Watkins, alderman 23rd Ward, and I find that the candidate has withdrawn and would entertain an objection, that the objections are moot, and therefore, this warrants dismissal.
So moved.
Second,
Second.
all those in favor?
Aye.
Motion passes. And the name of Nicholas George, Betsy Joanne Watkins will not be printed on the official ballot. Next case is 19 EBALD-051, Patricia Martinez versus Joel Zalco, Alderman 33rd Ward. Again, this is a candidate withdrawal, and I would entertain a motion that the objections are moot, and therefore this warrants dismissal.
So moved.
Second?
Second.
All those in favor?
Aye.
Motion passes, and the name of Joe Salco, candidate for office of Alderman of the 33rd Ward, shall not be printed on the ballot for the general municipal election. Next case is 19 EBALD-077, Moline.
Could we skip 064?
Zero.
Okay,
64.
let's go back to 19 EBALD-064, Gina Zuccaro and Emma Jean Robinson versus Justina Winfrey, Alderman 28th Ward. In this case, the candidate, I find, has withdrawn and would entertain a motion that the objections are moot and therefore warrant dismissal.
So moved.
Second?
Second.
All those in favor?
Aye.
Motion passes, and it's therefore ordered that the name of Justina Winfrey, candidate for office of Alderman for the 20th Ward, shall not be printed on the official ballot for the general municipal election. Next case is 19 EBALD-077. And that is Moline Zadan versus David Krupa, Alderman 13th Ward. In this case, the objections have been withdrawn, and there are no other objections pending.
Madam Chairwoman, despite the filing of the motion to withdraw in this case by the objectors, which will withdraw the objections, it's a little unusual, but we have a motion to strike, or a motion to dismiss filed by the candidate that also includes in the motion a request for referral to the Cook County State's Attorney for investigation and possible criminal prosecution. And that's an issue that's not necessarily withdrawn by the objector's request to withdraw the case. And so I therefore think that that is a matter that the board should consider if it would like. And I'd be happy to explain the circumstances if you'd like.
Yes, should we do the first motion, and then you can explain?
Well, let's
Good,
do
do it
this
together.
before the case is dismissed.
Okay. Why don't you explain?
Can I have a question? Procedural purposes.
Yes.
That's been properly voted. Under this particular noticing,
Well-
is properly considered that motion.
I would say yes, because this is noticed up for a final recommended decision, so it's noticed up for the entire case.
Just wanted to be clarified.
Yes.
I think so.
So this is a case where prior to the filing of the candidate's petitions, and therefore prior to the filing of the objections, this board received some 2,796 signature revocation affidavits. Under the Illinois Election Code, if you sign a candidate's nominating petition, your signature shall stay on that nominating petition unless you file a revocation. So it has to be a revocation affidavit has to be filed with the Election Commission, the election authority, prior to the filing of the candidate's nomination papers, and as I said, we received many of them. Some of those revocations were also filed along as a part of the objector's petition then, to try to show that those signatures would not be counted towards the candidate's minimum. As pleaded in the motion filed by the candidate and the candidate's counsel, only approximately 180 or so of the 2,600 some revocations that were filed were included with the objector's petition, and only a small number like that of the revocations actually applied to people who appeared on and signed the candidate's petition sheets. These affidavits are notarized affidavits in which each person, they're template affidavits, but they are also signed by and notarized, stating that the person did sign candidate Krupa's nominating petition. but it appears just on the face of the documents as compared to the nominating petitions that a substantial majority of those affidavits were not actually signed by people who did sign the candidate's nomination papers. The candidate has therefore requested a referral to the State's Attorney's Office for further investigation of possible perjury and criminal conduct. I would point out that this Board of Elections and this Board of Election Commissioners does have, a tradition of complying with and cooperating with any investigations that may go on. But here it's actually received a request for a referral. And I also see the candidate's counsel has taken the table. Maybe we'd like to give him an opportunity to address the board as
Thank you.
identify yourself.
Thank you, Mr. Lasker. Good afternoon, Madam Chairwoman, members of the board. Michael Dorff, DORF, on behalf of the candidate, David Krupa. I'm delighted that Professor Fraud is also sitting with us today. And we would never have discovered this fraud were it not for the filing of the Freedom of Information Act request. If we had not filed that request, all we would have seen were the 187 affidavits of revocation of signature that matched lines in the candidate's petition. Fortunately, and I really want to thank Mr. Lasker, Executive Director of the FOIA Officer, for the swiftness in providing our response, their response to our Freedom of Information Act request. So we filed the Freedom of Information Act request, and we discovered that there were 2,796 sworn revocation of signature affidavits, when the total number of signatures collected by the candidate were approximately 1,729. So without doing anything else, we knew that there were at least 1,000 false affidavits that were submitted with people swearing on oath, I signed David Krupa's petition, I wish to revoke my signature. Once the objection was filed and we were able to look at it, then we saw that only 187 matched, which means that there were over 2,600 false affidavits filed. We had, when we were scheduled for a hearing last Saturday, and a few hours before, Mr. Lasker informed us that and candidate and the objector's counsel informed me that they were withdrawing the objection. Out of a matter of prudence, because Saturday at 5 o'clock was the deadline for subpoenas, we also filed, just to be safe, a request for subpoenas, which requested not only all of the notaries, but also we did John Doe subpoenas in accordance with Rule 19 to find out who had walked around with these affidavits, soliciting them from residents of the 13th Ward. And the idea was that the notary, we would be able to subpoena the notaries so they could tell us who they were with, who solicited these affidavits. I believe that subpoena is certainly moot based on the withdrawal of the objection, but again, we wanted to be sure we met the deadline in case something happened today. There is clearly fraud. We don't know who did it. We don't know whose fingerprints are on it. In our original motion to dismiss, we included several affidavits from people who were supporting the candidate, who said that they were approached by persons stating that they either were representatives of the incumbent alderman's office or were precinct captains from the ward organization. We don't know who we certainly don't have, if we had had to do an evidentiary hearing, it would have been, you can imagine what it would have had been like. But we believe there is clearly within the four corners of what was filed with the board a clear fraud upon the board as well as upon the candidate and certainly upon the electoral process. And that's why we requested in our motion to strike and dismiss that this board refer the matter to the state's attorney so that with the appropriate resources, law enforcement could get to the bottom of what occurred here.
Okay. Well, thank you for your statement. At this time, and I think the state attorney's office has reached out to the board, and you have had communications. I'm not asking about those, but I just want to make clear for the record that they have. I do think that we need to inform the U.S. Attorney's Office because this is a matter possibly within their jurisdiction, and I think that it's important to notify them, and they can, if they so choose, they can investigate.
I think it would be good to notify the U.S. Attorney's Office if that's going to be the board's pleasure. I would also say we should, the candidate has also made the request to the state's attorney's office. They have called to ask me some questions about what's going on. This has been in the news, and they've seen the news. But the candidate's also requested to the state's attorney's office, and I would...
Should they
Exactly.
formalize that?
Yes. So, is there a motion? Is there a motion to refer the issue of the revocation affidavits formally to the state attorney's office and the U.S. attorney's office?
So moved.
Is there a second?
Second.
All those in favor?
Aye.
Okay. And Mr. Lasker, you'll take care of that.
I certainly will, with all due haste. I would also like to point out to the public that upon our referral, if there's going to be an ongoing investigation, it would be proper for the Board of Elections to not discuss the ongoing investigation. We normally like to try to, give some helpful advice to our voters as to things affecting their life in regards to elections. But with the inability to do that, I would like to suggest that members of the public have at least 2 phone numbers that might be helpful to them other than ours. One would be perhaps the Chicago Bar Association Lawyer Referral Service, which can be reached at 312-702-7101. And also the Cook County State's Attorney's Office does have an election fraud hotline where they answer questions and give opinions on what may or may not be election fraud. That phone number is area code 773-674-2729.
Thank you.
And at this time, is there a motion to adopt the hearing officer's report and recommendations and grant the motion to withdraw the objections?
So moved.
Is there a second?
Second.
All in favor?
Aye.
Motion passes, and it is therefore ordered that the objections having been withdrawn and there be no other objections to the candidates' nomination papers. The nomination papers are hereby legally valid in the name of David Krupa, candidate for election to the office of Alderman of the 13th Ward of the City of Chicago, shall be printed on the official ballot for the municipal general election to be held on February 26, 2019.
Thank you, Madam Chair.
Thank you, Mr. Gore.
Thank you.
Next case is 19 EB ALD-087, Linda Stamps versus Kenny Doss for Alderman for the 16th Ward. We can take that with the next one?
Different candidates.
Okay.
Yeah.
Oh, I'm sorry. Here the objections have been withdrawn and there are no other objections pending. Is there a motion to adopt the hearing officer's report and recommendations and grant the motion to withdraw?
So moved.
Is there a second?
Second.
All those in favor?
Aye.
Motion passes, and the name of Kenny Doss, candidate for election to the office of Alderman of the 16th Ward of the City of Chicago, shall be printed on the official ballot for the municipal general election. Next case is 19 EB ALD-088, Linda Stamps versus Jeffrey L. Lewis, Alderman 16th Ward. And in this case, again, the objections have been withdrawn Is there a motion to adopt the hearing officer's report and recommendations and grant the motion to withdraw?
So moved.
Second?
Second.
All those in favor?
Aye.
Motion passes, and it's hereby ordered that the objections having been withdrawn and there be no other objections to the candidates nominating papers, the nomination papers are legally valid, and the name of Jeffrey Lewis, candidate for election to the office of Alderman of the 16th Ward of the City of Chicago, shall be printed on the official ballot for the election. We now proceed to 19 EB ALD-089, and in this case, the candidate has withdrawn, and I find that,
No,
This is an objector withdrawal.
objecting.
I'm sorry, the objection, is there a motion to adopt the hearing officer's report and recommendations and grant the motion to withdraw?
So moved.
Is there a second?
Second.
All those in favor?
Aye.
Motion passes. And the name of Deborah Lane shall not be, I'm sorry, the name Latasha Sanders shall be printed on the ballot for the municipal general election. Next case is 19 EB ALD 106. Renee G. Owens, Peter Rivera, Renee Wozniak, Maria Origel, and Evelyn Razzo versus Deborah Lane, Alderman of the 15th Ward. In this case, the candidate has withdrawn and would entertain that any objections are moot, and therefore recommend dismissal.
So moved.
Is there a second?
Second.
All those in favor?
Aye.
Motion passes, and it is therefore ordered that the name of Deborah Lane, candidate for Alderman of the 15th Ward, shall not be printed on the official ballot. Next case is 19 EB ALD-110, Nathaniel Moore versus Flora Flo Digby, Alderman of the 7th Ward. In this case, the candidate has withdrawn and would entertain a motion that the objections are moved and therefore warrant dismissal.
So moved.
Is there a second?
Second.
All those in favor?
Aye.
Motion passes, and the name of Flora Flo Digby, candidate for Alderman of the 7th Ward, shall not be printed on the official ballot.
Madam Chairwoman,
Yes?
the next case, ALD 114, you may also call that with ALD 113.
Okay,
So that would be
We
on our
have-
list 13 and 15.
right. 19 EB ALD-114, Nathaniel Moore versus Clarence Davidson, Alderman 7th Ward, consolidated with 19 EB ALD-134, Jedediah Brown versus Clarence Davidson, Alderman 7th Ward. The candidate in both of these cases is the same and has withdrawn, and I would entertain a motion that the objections are moot and the case should be dismissed.
So moved.
Is there
Second.
a second? All those in favor?
Aye.
Motion passes, and the name of Clarence Davidson shall not be printed on the ballot. We will then proceed with 19 EB ALD-132, Kevin Bailey versus Anthony Driver Jr., Alderman of the 20th Ward. In this case, the objection has been withdrawn and there are no other objections pending. Is there a motion to adopt the hearing officer's report and recommendations on the motion to withdraw?
So, second.
Okay. And motion passes.
Well, all those in favor?
I'm sorry, all those in favor?
Aye.
Motion passes, and it is therefore ordered that the objections the nomination papers are legally valid and the name of Anthony Driver Jr. Shall be printed on the official ballot. Next case is 19 EB ALD 145, Matthew J. Ross versus Derek Curtis, Alderman for the 18th Ward. In this case, the objections have been withdrawn and there are no other objections pending. Is there a motion to adopt the hearing officer's reporting recommendations and grant the motion to withdraw?
So moved.
Is there a second?
Second.
All those in favor?
Aye.
And,
Numbers 17 and 18, maybe all together?
So Derek Curtis shall be printed.
Didn't put it in the ballot, right?
Oh, I'm sorry. Yes. I jumped the gun.
You did state that, Madam Chair. Derek Curtis shall be printed on.
I'm sorry.
yes, and the name of Derek Curtis shall be printed on the official ballot. Next we have two cases, related cases. 19 EB-0 MUN-001 Hector Escarzaga versus Richard Myers, City Clerk, City of Chicago. And related case 19 EB MUN-015 Daniel David Gerhard Rogers versus Richard Myers. In both of these cases, the candidate has withdrawn and would entertain a motion that the objections are moot and therefore the cases are dismissed.
So moved.
Is there a second?
Second.
All those in favor?
Just pick one.
Aye.
Good. Motion passes, and it's therefore ordered that the name of Richard Myers, candidate for the office of City Clerk for the City of Chicago, shall not be printed on the official ballot for the general election. Next case is
19 and 20, can we call together?
19 EB-MUN-018 Gina Zuccaro and Monique Cook Bay versus Richard Myers, and the related case 19 EB-MUN-09 Peter Gariepi versus Richard Myers for City Treasurer, City of Chicago. The candidate has withdrawn and would entertain a motion that the objections are moot and therefore dismissed.
So moved.
Is there a second?
Second.
All those in favor?
Aye.
Motion passes, and it's therefore ordered that the name of Richard Myers shall not be printed on the official ballot for the general municipal election. The next case is 19 EB-MUN-024 Hector Escarzaga versus Patricia Horton, City Clerk, City of Chicago. We have a related case, 19 EB-MUN-020, but I don't see it.
We don't call that case today. This is an objector's withdrawal, so it's specific only to case 2024.
And in this case, the objector has withdrawn his objections. And is there a motion to adopt the hearing officer's report and recommendations and grant a motion to withdraw?
So moved.
So moved.
Is there a second?
Second.
Second.
All those in favor?
Aye.
Motion passes, and it's therefore ordered that the objections of Hector Escarzaga are withdrawn, and this case is dismissed. The next case is 19 EB-MUN-025 Zach Blanks versus William M. Daly, Mayor, City of Chicago. In this case, the objections have been withdrawn. There are no other objections pending. Is there a motion to adopt the hearing officer's report and recommendations and to grant the motion to withdraw?
So moved.
Is there a second?
Second.
All those in favor?
Aye.
Motion passes, and it's therefore ordered that the objections having been withdrawn, there being no other objections to the candidate's nomination papers, the nomination papers are legally valid in the name of William Daley, candidate for election to the office of mayor of the city of Chicago, shall be printed on the official ballot for the municipal general election to be held on February 26, 2019. Next case is 19 EB MUN-027. There are two related cases here, 19 EB MUN-004 and 19 EB MUN-008. 027 is Jerry L. Jackson versus Catherine Brown Tycoon for mayor, city of Chicago. And in this case, the objections have been withdrawn. Is there a motion to adopt the hearing officer's report and recommendations?
Just for,
To grant the motion to withdraw.
just for clarification, that's only as to the case number
Exactly,
27.
027, exactly.
So moved.
Is there a second?
Second.
All those in favor?
Aye.
Motion granted, and it is therefore ordered that the objections of Jeffrey Jackson are withdrawn, and this case is dismissed. Next case is 19 EB MUN-028, Jerry Jackson versus Gary McCarthy, mayor, city of Chicago. In this case, the objections have been withdrawn. There are no other objections pending. Is there a motion to adopt the hearing officer's report and recommendations and grant the motion to withdraw?
So,
Is there a second?
second.
All those in favor?
Aye.
Motion passes, and it is therefore ordered that the objections having been withdrawn and there being no other objections to the candidate's nomination papers, the nomination papers are legally valid, and the name of Gary McCarthy, candidate for election to the office of mayor of the city of Chicago, shall be printed on the official ballot for the municipal general election. Mr. Lasker, this concludes the cases for today.
Do we have any requests for public comment?
No, if
That
there-
does conclude the cases, I'm sorry, I didn't answer your question.
Okay, thank you. And we have cases, we have cases to sign at this time.
Yes. Yeah, so we have final decisions for all the cases that you did just vote upon. And as I'll state one more time, that if there are any parties in the room, I don't think I see any, but when we mail these out, pursuant to section 10-10.1 of the Illinois Election Code, that will start the time clock for any party who is aggrieved and wants to seek judicial review.
Mr. Lusk, I think I also have a subpoena.
You do have some additional subpoenas.
So let's start the production.
What's his name again? Edward Lasker.
It's the same thing.
Sorry. Oh, you're right.
How are you?
Do we have a set time?
Well, we're still in an open meeting, we could talk about that
For the call of the
right now
chair?
if you want. You could either do the call of the chair, or if you want to.
We have a meeting at 9:30,
That's
that's
correct.
and so we can be right after that. Okay.
So that's a 9:30 meeting,
We could just do
10 or 10:30.
10. Let's do 10.
Let's do 10 and do
If you do them both at 9:30, then you can just
Right,
start as soon as you're,
Okay, do both at 9:30.
okay. Okay, is there a motion to recess until Thursday, December 27th at 9:30 a.m.?
So moved.
Is there a second?
Second.
All in favor?
Aye.
Motion passes. We're recessed. Thank you.
Thank you, Miss.